welcome to Legally Speaking with me, Tarun Nangia. Now we commence part 2 of our series, which speaks about how to ensure faster disposal of cases to, in a sense, push foreign direct investment in India. Also, how arbitral appeals, in a sense, should be disposed of faster by the courts. We continue our discussion from part 1. May I introduce my panel to you? I have with me Justice Arjun Kumar Sikri. He needs no introduction, but let me formally introduce. He has served as Judge Supreme Court of India. He is currently International Judge of Singapore International Commercial Court and very well known as one of India's busiest arbitrators. Welcome, sir. I also have with me Senior Advocate Parag Tripathi, a top commercial counsel at the Supreme Court of India. Good to see you again for part 2. May I also welcome Ryan Karanjawala, Managing Partner of one of India's leading litigation law firms, Karanjawala and Company. Welcome and good to see you again. May I also welcome Mahesh Agarwal, Managing Partner of Agarwal Law Associates, one of India's leading litigation law firms. Good to see you again. May I also welcome Advocate Rohan Shah, a very fine commercial mind, practices at the Bombay High Court and the Supreme Court of India. Good to see you again. And quickly, without much ado, we will get our discussion going from part 1. I'll go to Mr. Rohan Shah. You saw what happened in part 1. You spoke and Justice Sikri spoke, Mr. Karanjawala spoke, Parag Tripathi spoke, and Mahesh Agarwal spoke. That timelines have been given, but timelines are not followed. And that is why there was saying, you also said that there is a case for special courts. What should be done so that arbitral appeals are, in a sense, settled faster? What can be done so that timelines are met? NCLT is the best case in point. There is no timeline. Some matters are going on for 4 years. In about 3 or 4 minutes, Mr. Rohan Shah, if you could share what is the solution in your view?
I think the challenge we have, and as all the panelists had analyzed, maybe the key issue is discipline in terms of the court system, and that is discipline both at the end of the bar and in terms of how we conduct matters and take them forward. Justice Sikri rightly mentioned the whole case management system, where very tight timelines are set. You could also effectively lay down, the size of pleadings, the amount of time which would be given for lawyers to address, equally, time and rejoinder, all of which would really crunch the process to being both predictable and time-bound. And I think that aspect of that discipline, the moment it is violated to accommodate A or B or C, ultimately then opens the floodgates for everybody seeking accommodation. And when you accommodate everybody in the system, you really get a system which is chaotic, because all timeline-related provisions are sadly directory and not mandatory. There isn't a consequence. We have nothing to say that nobody can ask for more than 2 adjournments, right? Now, there could be the exceptional circumstance, but if this is actually followed very tightly, then that itself will have a cascading impact. The other point that I just wanted to make is, while much of the first part of the discussion rightly was on commercial litigation, which admits of arbitration, if we see the FDI perspective, you're vexed by several issues, right? Taxation for one. This process of going to a special tribunal in tax ultimately will still take you to a high court or to the Supreme Court. Now, the moment you go through the tribunal, you might sort of perceive that this has moved, relatively quickly, but you're back in the High Court or Supreme Court system, which again means you're going to wait 6-7 years. Now, from that perspective, our solution cannot just be, I am going to address the arbitration issues. We need a wider width in terms of how we will address these, because all of this, and the tragedy of this tax issue is, we have seen situations where people have exited their investment in India 16 years ago. Then the infamous Vodafone issue came. Then the retrospective amendment came. Then the litigation came. Now the Settlement Act came. So people who have gone home with profit and dividend have not enjoyed it because for 16 years they've been in a tax battle. Now that is not a good advertisement for FDI or investment. And I think therefore the lens needs to be a little wider. every potential point of litigation, how do you deal with it? And this issue of, are we creating a exclusive high-end litigation club? No, there is, I believe, a real public interest, which is, if you want employment, if you want investment, then this is not about a club of exclusive high-end litigators. It's really about, we need this to foster the sort of investment and the sentiment that we need.
Thanks for that introduction. I'll go to Senior Advocate Parag Tripathi. I come back to my point, Mr. Tripathi. When you argue matters for top corporates and time runs out, I mean, in a sense, time is running out, the interest costs are going off for these corporates, they're spending money on litigation. Do you think they rethink that, okay, we must not put money in India anymore, let's look at some other market, whatever we've invested, but let's diversify. And India loses bit by bit whenever a CEO thinks, okay, not this country, let me put it in some other country, because money is getting stuck here and India loses out. And also then your opinions on the first two questions on arbitration appeals to be decided fast. And secondly, on the timelines not being followed, of course, there is this whole question of appointments, which we have to deal with. Thankfully, we have to thank Justice Ramanna, the Chief Justice of India, that at least in his term appointments have got going. But your point.
See, Tarun, I think the one principle, we have Satyamev Jayate written behind the chair of every distinguished judge before whom we appear in the courts. I think we should have one more slogan. And it's not merely a slogan, it's a very important philosophy. Don't make best the enemy of good. The interference at appellate level is invariably because the appeal court feels persuaded by excellent arguments that perhaps the final order could have been better. I think time has come when we have to accept the principle laid down by a very distinguished professor of Yale, who said that your right to adjudication ends with the first primary adjudication. After that, the appeal right is only if it is going to affect the society as a whole. So therefore, the principle has to be the principle which you apply in an arbitration proceeding. That has to be the principle, according to me, even in normal civil litigation. If the view taken by the court below is a plausible view, the matter comes to an end. And this is not an extraordinary principle. This is a principle which has been accepted by the Supreme Court when you deal with appeals against interim orders. You have to let the final decision lie unless you feel as an appellate court that there is something so grossly wrong that it cannot be allowed to stand. Now, more than judges, this is something which has to come to us as lawyers. We have to understand and advise our clients, because till we keep on finding with ingenuity some aspect or the other, this will never end. And the principle will remain that, well, this would have been a better order. I think Justice Sikri raised a very important point. Why is it that when we are at the level of moot court as students, we can deal with complex issues in 40 minutes? And why is it when we are arguing as a counsel, we are unable to deal with it in at least in more than 10 days? I think there's a very nice Urdu couplet on that, which says, "Ghar se chale the karke har baat saaf hum, कहने में उनके सामने हर बात बदल गई." And here, why has it changed when you address it? Because as a counsel, every day's additional hearing is not something which a counsel dreads. It is an additional set of fees. I'm not saying we extend a hearing because of the fees, but there is no compelling reason for us to say that we will finish it in that time. Why does the moot court student finish it in 40 minutes? Because he knows that after the 41st minute, he won't be entertained. That has to come in final hearing as well. And that will come in only when you have costs. Mr. Tripathi, you argued for 3 days. Very well, I will put costs for 2 days, whether you win or you lose. They do that in international arbitrations. All our distinguished panelists would know that. There have been cases where you have succeeded, but the costs have been put on the successful party by saying that you unnecessarily raised these arguments which were unnecessary for the adjudication, and we lost 5 days. These 5 days costs are being put on you. So that is very important. The relief has to be holistic. And our appellate courts have to be freed from the tyranny of us lawyers' arguments that, look, this order could have been better worded, could have done more justice. That is not the concern. The concern is it a plausible view? Is it a view which a reasonable judge could have taken? If it is, then I'm sorry for you. I'm not going to proceed further. A great English law lord had once said, somebody said, your lordships do justice all the time. He says, no, we do justice according to law. And that is something which has to go down more than with the judges, with us lawyers. So when we advise our clients, we tell them, you've had your day in the court, and that's where it ends. So that is the important part. As far as arbitration is concerned, by and large, as and when an appeal against 34, that is a challenge to an award, sees the light of the day, the answer normally is that the courts won't interfere. But then, as has been rightly pointed out by the panelists, it takes time for the appeal to see the light of the day. And then there is the problem of execution.
Thank you so much for that points that you shared. And when you shared that couplet, I remembered a couplet in Hindi too, which, when corporate house fights a court battle for 7 years and gets an order in which he is not satisfied, the promoter says, nahi ab koi anban nahi, bas ab pehle sa man nahi. So he takes his investment and goes out of the country. So the couplet means for my viewers that there is no problem anymore, but I don't have any, I don't have any heart to invest anymore. I'll just go somewhere else. I'll go to Mr. Karanjawala. Now, typically in a large law firm, litigating law firm like yours, you get top business houses, but they are well funded. They also have an appetite to fight. But do you think even they get tired with the delay in court system? And many times there is only one solution cited, that in Delhi High Court, instead of 72, there are only 36 judges. So just fill in the judges and things will fall into place. Do you think that is the solution? That let the appointments be full and then judge if the system performs? Or what other inputs have come today on the panel that also matter? Your inputs on that.
So first, let me take what Parag said, that ultimately, the best should not be enemy of the good. That's what Parag said, because one shouldn't keep striving to attain a perfection and therefore lose out on the real thing by elongating the whole case for too long. The whole problem with this is this, that you are dealing at every level with human beings. There are judges, they have divergent views sitting across the bench on the same day in the same court. So it's very difficult for a lawyer to predict what is exactly going to happen. Therefore, when he's faced with a client who wants to take a chance, it's a very bold lawyer who will say, no, I don't think you should take the chance at all. If the law is clear, if the decision is broadly been consistent, then you can advise clients. But otherwise, the system itself is so uncertain that between the lawyer's desire not to be caught out on the wrong foot and the client's desire to get something, very often people take that chance. Also, the treatment that the same case will get in court A will not be the treatment that the same case gets in court B. So ultimately, you are unlikely to have a situation where either the client puts on himself a sense of discipline or the lawyer puts on himself a sense of discipline and doesn't approach. The discipline that is today put on the client, especially in cities like Delhi and Bombay, is that the costs of litigation have become prohibitive. So if top companies also find it difficult to fathom what kind of fees they have to pay to get the top lawyers. So sometimes that makes them say, no, I'll go ahead and I'll settle. That's one thing that happens. But otherwise, corporations, where they feel they have been wrong, continue to have an appetite to litigate. They don't have an appetite to pay the kind of fees today that they are forced to pay, but nevertheless, they want to take their chance in court. The real solution will have to be, which is the obvious solution, that any institution to function effectively must be manned at full strength. And that is something that you have to tackle. If you have twice the number of judges hearing commercial cases as there are today, then the time in which that commercial case will be disposed of will be half. That's logical because you have twice the strength. So the work should be divided and it should finish in half the time. And somehow there can be no real court management unless you tackle the incipient problem, which is that there should be sufficient judges for the kind of litigation the country has to face, especially when the Supreme Court ultimately is a court of almost all jurisdiction. Almost any case that starts off somewhere in India can, if the litigant so chooses, ultimately end up in the Supreme Court. So when such a situation is there, you have to see that every institution is manned at full strength. There are many other things that you can do, and the panelists have suggested it. But I think the fundamental thing will be to ensure, if you really want FDI to come in, if you really want the government to prosper, that you tackle the root cause, which is that the courts are not at their full sanction strength.
Mr. Mahesh Agarwal, now in a top law firm like yours, which primarily deals in the litigation space, all these high value clients are wanting not only listing but back-to-back hearings, which many times are possible, many times they are not possible. And their exasperation grows because they are not getting hearings. Do you think whatever we discuss today will be futile in absence of judges not being appointed quickly? Because you can put any number of timelines to your case, but if there are less number of judges, we'll see what happens in NCLT. You know, timelines have gone out of a whack. Do you think that what Justice Ramanna, in a sense, started needs to be taken to conclusion with very quick appointments in the next 2 years, so there are no vacancies?
So see, I'll just highlight the importance of the topic we're discussing by these two numbers, that in ease of doing business, we have advanced from 186 to 63 in the last 5 years. And for contract enforcement, we are remaining at 163 out of 190. Now, if we advance in the contract enforcement sphere in the ranking, in ease of doing business, we'll go far ahead, which will attract investments. Now, on the judges, we keep blaming the court and the judges that matters are not getting decided. They cannot be decided because judges are sitting till 6 o'clock, 7 o'clock in the evening with 100, 120 matters before them. It is impossible for them to decide. Yes. So therefore, to meet the requirement of filling up the vacancies is very, very critical and need of the hour. Now, one positive suggestion which I had in mind is that under the Arbitration Act, as also in most contracts, there is a provision for pre-arbitration mediation. So before you go to court or before you go for arbitration, there's a mediation system. Most of the time the mediation fails because at that time the parties are tight-fisted. Everybody thinks he has the best case. I would suggest that post the arbitration, once the award comes, or in a court process when the trial court gives the judgment, before appeal, there should be a mediation. Because by then the parties know their strengths and weaknesses. They have a judgment they have a judgment to consider. A mediation at that level can iron out many differences. And then if at all a party has to go in appeal, then the scope is limited. So if you have a mediation post the first level of adjudication, at that stage, you will limit the number of appeals. Now, that is also critical for one more reason, that now the Supreme Court has said that when you challenge an award, the scope of the appeal court is very limited to either set aside or to confirm, but not to modify. Now, till that anomaly is corrected, it is important that things which can be addressed and agreed to are done before the appeal court. So parties can sit through either together or with an independent mediator, not the arbitrators, but some other mediator, and iron out the differences. That will limit number of appeals and also the scope of appeals, giving us a huge impetus on contract enforcement.
Thanks for that input. I'll go to Justice. You wanted to come in, Mr. Karanjawala?
No, I just said a very good point Mahesh was making.
Okay. Thank you so much. I'll go to Justice Arjun Kumar Sikri. You heard the counsels and the managing partners of law firms. Appointments issue came up. Rohan Shah raised this issue of timelines and quicker disposal, special courts. Issue was arbitration also raised. I mean, somebody who's been in the Supreme Court as a sitting judge, Where do you think the solution lies? Of course, we saw Justice Ramana taking some steps, and appointments process actually now started. He's pushing. I mean, but like now, technical member appointments in NCLT are going to happen soon. The applications have come in also in Delhi High Court, other courts. So your point in a holistic manner, how do we get a solution to this problem?
I think this point is very well made, and nobody can deny it. That number of judges, adequate number of judges have to be there. And as rightly mentioned, that if there are 100 cases, 80 cases, 70 cases before one court, one day, how a judge can tackle with all this. And India is one of the poorest country when it comes to judge population ratio. And I think maybe it is 23 or 24 judges per million population, whereas I think it is around 125 per million in America. And the same position would be in Western countries, and even country like China. The judge population there, it is more than 300 per million population. So it is the need and imperative need that we have to have sufficient number of judges when the arrears are so much. We have today more than 3 crore cases pending in all courts, and of course at the high court levels also. And during COVID, the figures have gone much higher again. So therefore, that cannot be denied at all. At the same time, I would say, and what we have discussed, and if I may again summarize that at the same time, we need efficient judges. We need the judges who have technical expertise. We need the judges who are able to have good case management and court management, and are able to ensure that the cases are, argued before them in a time-bound manner, and not more than a particular time is given, and the cases are, not unnecessarily adjourned. This is what all have said. What I feel is that, if I may say, in addition to that, two things which are required. One is, which Mahesh has hinted, is that techniques to adopt ADR into the litigation system. We know ADR is there, but when it comes litigation system here, what he mentioned, that the award is given and at that stage. But when it goes to the court also, a case at any stage, if it's commercial court and it was not a matter coming from the award, but a suit which is filed, or when it is an award also and the challenge to that award is made, whatever is the stage or whatever is the type of case, or it is in appeal under Section 37, etc. At what stage and how a particular bench can bring in mediation and can, in a way, persuade the parties to settle. We have in mediation one thing which is called E&E, early neutral evaluation, because at that time no adjudication has taken place, there's no award. But then the mediation, in order to show both the parties that where you stand, because many times I don't want to budge from my position because I think that I'm very strong. And that may be the stance taken by both the parties. And that's why they are not settling. They think that, no, we are going to win in the court. But when it comes to this, that early neutral evaluation by neutral person who tells what are the weaknesses and what are the strengths of the cases, respective cases, then that facilitates mediation at that time or settlement between the parties. So that may, after the award is given, of course, it may be, I would say it may not be an easy solution at that time, because once the award is given, yes, parties can still settle insofar as the person in whossoever award has come, he still wants, he has not seen the, money, color of money, and therefore will say that, okay, I may still settle the matter so that it doesn't go, from appeal to appeal, as Ran said about that any case can land up to Supreme Court. So it is at the High Court level, at first stage, Section 34, but before that, parties can arrive at settlement. So that is one, the judges should adopt this technique. And there was certain out-of-box thinking also. And I would, in the first episode, Mahesh had said about the reasons for admitting appeal. I give you, I tell you two anecdotes and two things which I tried to do as a High Court judge, but failed on both the occasion. when Section 34 applications came before us, and me and two more judges, and I can name them also, Justice Sanjay Kaul and Justice Pradeep Nangia, we passed the orders by going into the grounds of challenge to the award and saying that, look, this challenge doesn't come within the four corners of Section 34. So why I should issue notice? We started passing the orders in those cases, 7 or 8 page order, giving, dealing with each objection and saying that it doesn't fall under 34 and dismissing that. But why I said we failed, division bench in one of the cases overturned us. They set aside, they said no. Once the objection is filed under Section 34, it is necessary to issue notice and hear the other side. For whatever that old thinking which was there, otherwise had that been adopted, we started doing it way back in 2004-5, things would have been different. And likewise, when he talked about partial enforcement under Section 34 earlier, there was no such, the position was automatic stay. I still remember I had given one judgment, although at that time, in a way, sidetracking that look, no, in spite of that, like Order 41, Rule 5 CPC, where the stay can be given with conditions, so why not we impose conditions? But at that stage, again, of course, the letter of law was very clear at that time. And again, I was overruled saying that no, once the objections are filed under 34, it's an automatic stay, execution cannot take place. So, but fortunately, the law has been amended to that extent, at least by the legislature now. So, but what I'm trying to emphasize from here is that there are some of the bold moves which the judges have to take, and they have to come out with some out-of-box thinking as to how to deal with these matters. So I think it's one has to attack from all sides. Number of judges, the case management, etc., time management of the cases, arguments, how cost has to be imposed, and of course, at the same time, some innovative methods as well.
Thank you so much for that very comprehensive answer. A very fine set of points have come out of our two-part series on how to dispose of cases faster to, in a sense, increase foreign direct investment in India. Now we can understand the judiciary is concerned, the government of the day is concerned, but isn't it, as the panel said, that the onus is also on the government and the judiciary both to first see that the whole judiciary is fully staffed, and then ensure then find out issues that why disposal isn't happening. Of course, timelines have to be followed, but can the judiciary be faulted if many high courts are operating at half the strength? At 50% strength, can disposals happen? Of course, the whole issue of tribunals also came up, and we saw what has happened of NCLT and NCLT. We sure will take up in one of the coming episodes how to solve that, because that's becoming another problem, and everything is now ending up in the court, which is the High Court and the Supreme Court later on. But thank you so much, Justice Arjun Kumar Sikri. Thank you for your time. Senior Advocate Parag Tripathi, Ryan Karanjawala, Managing Partner of Karanjawala and Company, Mahesh Agarwal, Managing Partner of Agarwal Law Associates, Advocate Rohan Shah. Appreciate joining us, and thank you so much for your time. Thank you, viewers, for joining in. We will be back soon with another topic. Thank you so very much. Bye.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.